Competition regulation. In this short video, we will briefly consider how competition is regulated in Australia. We consider competition regulation in the same topic as consumer protection because there is a very close relationship between competition regulation and consumer protection. It is widely believed that competition within a market is good for consumers and good for the economy. When there is a single provider of a particular good, what we call a monopoly, it is likely that the prices will be high and the quality of the goods will be low because there is no incentive for the provider to do anything differently. But when there is healthy competition within a market and there is more than one supplier of a particular good, it is more likely that the prices will be lower and the quality of the goods will be higher because those providers will be competing with each other for custom. This is, of course, good for consumers. Competition law seeks to protect and enhance competition by regulating and prohibiting certain actions by businesses, including certain arrangements between competitors and other agreements that artificially maintain or inflate prices. If competitors are free to make agreements with each other, for example, to all agree that they will charge a particular price, then the benefits of competition are undermined and it is equivalent to having a monopoly. And so the law closely regulates the way competitors make agreements with each other and strives to ensure that competitors actually compete with each other rather than collaborate and collude. Competition in Australia is regulated by the Australian Competition and Consumer Commission, or the ACCC, under Part 4 of the Competition and Consumer Act 2010. Part 4 of the CCA promotes competition by prohibiting certain trade practices that have the effect of substantially lessening competition in the market. We will consider 8 specific practices that are regulated or prohibited by the Competition and Consumer Act. The first type of conduct that is prohibited is cartel conduct. A cartel is a contract, arrangement, or understanding between two or more competitors that lessens competition by, for example, fixing prices, controlling outputs, rigging bids, or allocating customers. Cartel conduct is prohibited by Section 44 ZZRJ of the Competition and Consumer Act. Cartel conduct is a per se offence, which means the conduct is illegal, regardless of its actual impact upon competition in the market. So it doesn't really matter whether or not the conduct has had the effect of substantially lessening competition. The simple fact that two or more businesses have engaged in cartel conduct is enough to establish that the businesses have broken the law. An example of cartel conduct is the Trade Practices Commission and TNT Australia. 3 of the businesses involved in the commercial freight market in Australia were shown to have colluded and reached agreements with each other to the effect that they would divide up the Australian market in a particular way and maintain their shares of the market artificially. So, for example, if one of these businesses lost a customer to one of the other businesses in the cartel, that other business would hand back another customer so that the shares of the market was maintained. In fact, if one of the businesses ended up with too many customers, they would in fact deliberately provide very poor service to certain customers in order to make those customers move to one of the other members of the cartel. All 3 of the businesses in this cartel were issued with substantial fines. A good example of cartel conduct is price fixing. A business is not permitted to make a deal with its competitors that they will all charge the same price for particular products or that they will all raise, lower, or maintain their prices. However, what looks like price fixing is not always actually price fixing. Just because all of the businesses within a particular market are raising and lowering their prices simultaneously, it does not mean that they've actually agreed to do so. It may be that one of the businesses is in fact a price leader, and when they raise or lower their prices, all of the other businesses in the market follow suit. This is price leadership, and price leadership is not actually illegal. The second type of anti-competitive conduct prohibited by the Competition and Consumer Act is misuse of market power. If a business has a substantial degree of power in a market, it cannot take advantage of that power to eliminate or substantially damage a competitor or prevent the entry of a person into that or any other market. And this is prohibited under Section 45 of the Competition and Consumer Act. A good example of misuse of market power is predatory pricing. And this is when one of the larger businesses within a particular market charges an unrealistically low price for a product in order to force a competitor out of the market. For example, in Victoria, a new manufacturer of Besser block bricks invented a process that would make it possible for them to manufacture and sell these bricks at a very, very low price. Boral was alarmed by the possibility of a serious new competitor entering the market, and so they lowered the prices on their own Besser block bricks to the point that the new business could not possibly compete. And Boral made a loss, of course, by lowering the prices of those bricks, but they were a large enough entity that they could get away with charging those very low prices until the new competitor was forced to exit the market, at which point Boral raised their prices back to normal levels. This is a clear example of predatory pricing and a misuse of Boral's market power. Misuse of market power is, like cartel conduct, prohibited per se, which means that, again, it is not necessary to prove that the conduct has actually reduced competition in the market. The simple fact that the business has engaged in this conduct is adequate to show that the business has broken the law. The third type of anti-competitive conduct is resale price maintenance. A business will engage in resale price maintenance in breach of Section 48 of the Competition and Consumer Act if it imposes a minimum price upon resellers of its product, or sets a price that retailers are likely to understand is the minimum price, or agrees with retailers that they will not advertise its product below a specified price, or induces a retailer not to discount its product, or threatens to refuse supply to a retailer to force them to comply with any of the above. So resale price maintenance is when a manufacturer or wholesaler insists that the other businesses that were responsible for selling their product retail are only permitted to do so as long as they sell the product at or above a particular price. This is something that occasionally the manufacturer or wholesaler of a prestige product will do in order to make sure that the prestige product maintains a reputation in the market as a prestige product and isn't sold cheaply or discounted. This is, of course, anti-competitive because retailers, as separate businesses, should be entitled to sell the product at whatever price they want. And so a business that does try and force retailers to maintain the prices of the products being sold is engaging in resale price maintenance and is breaking the law. Resale price maintenance is also prohibited per se. The fourth type of anti-competitive conduct is primary boycotts. A boycott is an action by an individual or a group that prevents or is intended to prevent another individual or group from buying or selling products in a market. A business is not permitted to agree with its competitors that they will collectively refuse to deal with a particular competitor, supplier, or customer. In other words, businesses are not allowed to work together to gang up on another business in order to force them out of the market. A secondary boycott occurs if two or more businesses put pressure on another business with whom they have no dispute to discourage them from dealing with the target of the boycott. For example, if two or more private education providers were to become concerned that a new school is entering the market, and so those private education providers who are currently in the market get together and contact various local bookshops, telling them that if those local bookshops supply books to the new school, those existing education providers will refuse to have anything to do with those bookshops. This is an example of a secondary boycott. Two or more businesses putting pressure on another business, the bookshops, to boycott the target, the new school. This is a secondary boycott, and this is a breach of the Competition and Consumer Act if it is shown to have the effect of substantially lessening competition in the market. The sixth type of anti-competitive conduct is exclusive dealing. Section 47 of the Competition and Consumer Act prohibits two types of exclusive dealing: full-line forcing and third-line forcing. A business will engage in full-line forcing when it refuses to supply its product unless the buyer agrees not to buy products from a competitor, or not to supply products acquired from a competitor, or not to resupply its product to a particular place. So, for example, if a manufacturer or a retailer were to insist that a particular shop only stock its products and no one else's products, it would be engaging in full line forcing. Massey Ferguson Australia, for example, in 1983 was found to have engaged in full line forcing when it insisted that retailers of farming equipment only stock Massey Ferguson equipment, otherwise Massey Ferguson would not supply products to those retailers. Third line forcing occurs when a business makes the supply of its products to a customer conditional upon the customer also purchasing the product from another business. For example, a few years ago, a number of travel agents were found to have breached the Competition and Consumer Act because they were insisting that when customers purchase their travel products, they also purchase travel insurance from a related entity. This is third line forcing and is an infringement of the Competition and Consumer Act if it is shown to have the effect of substantially lessening competition in the market. The seventh type of anti-competitive conduct is unauthorized mergers. Now, mergers are not themselves illegal. They're in fact quite common. When two or more organizations agree to join together to form a single organization, usually because of the resultant cost savings and economies of scale. But if a business attempts to merge with another business and the effect of doing so will be to substantially lessen competition in the market, then it will have in fact infringed Section 50 of the Competition and Consumer Act. When considering such a merger, it's usually appropriate to have the merger assessed by the ACCC in terms of its potential impact upon competition, and to only proceed with the merger if the ACCC authorizes the merger. The final type of anti-competitive conduct is the catch-all agreements that lessen competition. A business cannot make a deal with one or more of its competitors that is intended to or is likely to reduce competition in the particular market. The important point is that in order to establish a breach of these provisions, it does not need to be shown that the competitors have finalized a formal agreement or a written agreement. It is sufficient to show that they have reached an arrangement or understanding. So the arrangement can be an informal one as long as evidence can be found that the arrangement exists. The business or businesses will be shown to have infringed the Act. What are the consequences of a business being found to have engaged in anti-competitive conduct in breach of the Act? If a breach of Part 4 is established, the federal court can grant a number of possible remedies, including a fine, an injunction, a divestiture order in the case of a prohibited merger, in other words, forcing the businesses apart again, an action for damages, a corrective advertising order, an adverse publicity order, enforcement of a written undertaking given to the ACCC, and/or a declaration. The penalties are substantial. If the business is not a corporation, the maximum fine is $500,000 per breach. But if the business is a corporation, the maximum fine will usually be the greatest of $10 million per breach. Or if the court can determine the value of the benefit that is obtained directly or indirectly as a result of the breach, 3 times the value of that benefit. Or if the court cannot determine the value of that benefit, 10% of its annual turnover.